No, why is it before this bench?
That there is an IA 641 of 2020 that flagged, but that was for the father's death, and that obstacle
infructuous
is
now.
already over.
That's right. 641 of 2020. The present application is already infructuous and is disposed of as such. There is a 284 of 22.
You'll also can peruse the order dated 4/11/2015. 4/11/2015.
No, he's again asked for interim bail on 28/2/2022.
Before this bench, because earlier bail application has been rejected by the bench where minor Honorable Justice S.K. Sahu was a party.
No, earlier he had gone to the Supreme Court. The appeal was asked to be disposed of within 1 year. But because of COVID, it could not be disposed of. So he's moved another IA 284 of 2022 for interim bail.
Yes.
I don't know whether that's been listed so far.
Plus 284 by 2022 is for bail.
No, 284 for 22 is for interim bail.
No, noting, you lost me, see the noting.
I don't have the noting.
Yes.
Just see the application itself. Oh, bail or interim bail.
Yes.
He simply says bail or interim bail. How long has he been in custody?
My lord, more than 15 years.
15 years.
No, but one thing, Mr. Kotkia,
Yes, ma'am.
you have filed an application for enhancement of sentence.
Yes, ma'am.
How that is maintainable? There is a separate provision in CRPC under section 377 CRPC. You are to file an appeal for that. If you want this life sentence to be converted to death sentence because it's a rape and murder of a minor girl.
Yes.
So you are to file an appeal under 377. How this interim application will be there?
It is because being an appeal, it is an elongation of the trial. Here you also can assess the evidence, and that is the reason why we have filed an application for enhancement of sentence.
He has been, Mr. Katkia, he has been found guilty, sentenced to life. You say that this sentence is insufficient. You punish him, sentence him to death sentence.
Yes.
So whether there is no separate provision for filing an appeal against such inadequate sentence.
Let me examine that.
Please examine 377 CRPC. It says about filing a separate appeal for that, not that any interim application.
I'll examine and I'll come to this.
No, but what about the current bail application? He's been in for 15 years.
This paper book is ready, so
Yes, paper book is ready.
We can set it on for final hearing.
it is up to.
Yeah, I can give a firm date because I'm now taking up those criminal appeals. Are you ready to argue the appeal, sir?
Any date, my lord, next to any date, my lord.
To argue the main appeal.
Yes, my lord.
Counsel with the appellant status is ready to argue the main appeal itself. You just put down this IA 284 of 2022. This is an application praying either for bail or interim bail, pending the final disposal of the appeal. However, counsel with the appellant states that he is ready to argue the main appeal itself. We'll stop it to see that the paper books are also ready. Consequently, the present application is not disposed of at this moment and is kept pending. Can you say criminal appeal 23 of 2014 list for final hearing on 29 September? All right.
Item number 2.
Not this way.
Item number 2.
In this case, direction was given to us to obtain instruction on a particular point. But I humbly pray your lordship to grant me 2 weeks
Whether
more.
from 1st August 2006?
Yes, madam. Yes. I have written a letter, but you have not obtained it. 2 weeks time may be granted as a last chance to get the instructions.
At the request of Mr. Devakantavati, learned AG, who needs more time for instructions in terms of the order dated 15 July 2022. List on 14th October.
We are giving a short note for
Okay.
review. We have made out a case.
All right.
So let that be taken on record. We have circulated copies.
All right. All right.
For the honorable second judge also, we will be giving it.
All right. All right.
So let that be taken on record.
All right. The note of submissions of learned senior counsel for the original petitioner be placed on record. All right. Right, sir.
We are great.
Good afternoon, sir.
Supplementary list for orders item number 1.
सर प्रणाम मैं अपोजिट पार्टी
Item number 2.
आइटम नंबर 2
अभी पहला आइटम बुलाया है, आप वेट करो सर.
ठीक
Item number 2. Sorry, item number 1. CMAPL 779 of 2019.
None appears dismissed on our prosecution.
Item number 2.
Here, my lord, I am appearing for the review petitioner, my lord. This is a case, my lord, where the my client happens to be the married wife and having 2 children. Her interest is pitted against that person who is claiming to be the wife. And the review is sought on the ground that the application for restoration has been dismissed by the lower court. I had filed a CP, right, CP number 114 of 2001. That of 2001, that was subsequently dismissed. Now, against that matter was preferred. In the matter, it was again said that the application for condonation of delay be filed and be heard. But the learned lower court again turned down my application and said, no, that is barred by limitation, that too by 7 months. Now, your lordship, I'll take your lordship to the impugned.
Mr. Das, the writ court has, sorry, the appeal court has discussed the entire matter in para 13.
Grateful, your lordship, only page 31, the entire delay has been construed to be 7 months. And what I pray that 7 months is actually not there, because that the my lord, while passing the judgment, has lost sight of the fact that it was before the Honorable Supreme Court by virtue of SLP.
Whatever that may be, but the court, the appeal court has come to a conclusion that you had knowledge at the time of taking up the review application. So matter the plea of the matter taking pending before the Supreme Court cannot be a ground.
Well, only your lordship may kindly bear with me. Only one paragraph, page 31.
And that will amount to assess the matter on merit itself.
In fact, this
that cannot be in a review application.
Yes, my lord, only one prayer I'll make. In fact, the 7 months delay which has been construed by this honorable court in the impugned order, in fact, that 7 months also included the period of the passing of the judgment. 1 month, it was there from the date of hearing. So all this has been lost sight of in the 7 months. That is what the...
There is a delay. There is a delay.
No, not...
It may be 7 months or 6 months. That
only...
There is a delay which has not been explained.
Only 1 month delay. And my lord, the entire...
No.
Yes, your lordship may see page 30.
If that be so, that amounts to reappreciation of material on record.
Correct.
No, that was before the honorable court.
Yes, that amounts to appreciation of material on record.
Yes, the date of hearing of when I was...
Cannot be taken up in a review application.
Yes, my lord, that is the error on the face of record, in as much as that the knowledge which was given to me, that was in the month of February, and the judgment was passed in the month of March. That 1 month again gets excluded. Against that, both of the petitioner as well as the opposite parties went to SLP. 4 months delay in the SLP dismissal. So that 5 months is also excluded. Thereafter, I filed the restoration. That 6 months has been explained. That is what, but that has been lost sight by the impugned judgment. I'll just take your lordship one paragraph only, 31 page. there is no other document available on record to show that the copy of the order dated 11/3/2003 passed in CP number 114 of 2001, which has been dismissed, was in fact served on the learned counsel for the appellants in course of the hearing of matter 15 of 2004. Mr. Panda, learned counsel for the appellants, also drew our attention to certain notings in the order sheet of matter 15 of 2004 to strengthen his arguments to the effect that copy of the aforesaid order was never served in the appellant in the course of the matter 2015-2004. It is apparent from the record that a copy of the order dated 11/3/2003 was served on the learned counsel on 18/2/2011 in course of the hearing of review number 188 of 2010, accepting the same to be the date of knowledge of the appellants regarding dismissal of CP 114 of 2001. We proceeded to scrutinize the records. On perusal of the petition under Order 9, Rule 9 of CPC, as well as petition under Section 5 of the Limitation Act, miscase such and such, it is apparent that no explanation has been offered for the delay in filing the petition under Order 9, Rule 9 CPC after the appellants came to know about the dismissal of CP number 114 of 2001. It appears from the case record that there is a delay of 7 months in filing of the petition under Order 9, Rule 9. So this 7 months, out of the 7 months, 1 month was for the judgment to be delivered, and thereafter, after the judgment, the parties moved to the Honorable Supreme Court. There was 4 months delay.
No, the date of knowledge cannot be shifted like that.
Yes, that is what
The limitation starts from the date of knowledge.
Yes, your lordship
Yes.
accepted that my date of knowledge.
And that is 18/2/2011.
Yes,
Yes.
correct, my lord. After that, 18/2/2011, to my filing of the restoration application, there was a 7 months delay.
Maybe. That application didn't prevent you to file an application for restoration.
Not follow, my lord.
Sir,
That from 18 to 2011 to 18/9/2011, that 7 months, the lordships are held to dismiss.
That cannot be a ground to delay in, that cannot be a ground for delay in filing the restoration application.
Yes, but the restoration application was 7 months delay only.
Yes. That's what the court has held, that it is 7 months delay.
Grateful, your lordship. Out of the 7 months, 1 month had been only for the passing of the judgment in that matter. So that 1 month has to be excluded.
All right.
Thereafter 4 months in SLP, my lord. So your lordship may also see the interest of the lady who was approached, having 2 children. So only and she's an out of state person. She's not belonging to Orissa. So that 1 month can be explained by me. But 7 months is not correct in as much as that 7 months included the period of judgment as well as 4 months before the Honorable Supreme Court.
Mr. Das, it will amount to reappreciation of material on record.
No grounds made out for review. The review petition is dismissed. All right.
sir,
Right.
sir, please. Sir,
So we have dismissed his case.
sir,
We have dismissed his case, madam.
thank you.
Yeah.
Sir, many kindly thank you. सर 1 WPC केस सिंगल जज कोर्ट नंबर 2 में मेरा पेंडिंग एडॉप्शन डीड उन्होंने कहा है आपसे मिलने के लिए। जज को अलॉट करने के लिए क्योंकि वो नहीं देख रहे। कोर्ट नंबर 2 सतपति सर
Just ask her to meet the DR judicial. एक ऑफिसर के पास भेज देते हैं इसको।
जी।
ठीक है।
Just submission item number 1.
Please, your lordship. Writ petition was dismissed pursuant to order dated 11/7/2022 due to my lord default of the previous counsel.
What's the main matter about, sir?
Para 3, I have stated the previous
What is the main matter about?
matter of my resumption of land and imposition of penalty under section 3B of the ODLS Act.
And without giving any reasonable opportunity of hearing, the order has been passed by the Tahsildar. Under Annex 3.
Notice came to you or did not come to you?
No notice has been issued.
When did you buy the property?
Because the petitioner purchased the property in the year 1992.
92.
My lord.
Well, this is a appealable order, so under section 7, you can approach under section 7 of the OGLS Act, you can approach let it be relegated to the only, I don't have the petition, only if the sale deed is.
Yes, sale deed it says is earlier. There is a copy of this registered sale deed 20th January 92.
92, ma'am.
Order. You say for the reason stated therein, the order dated 11 July 2022 is recalled. And writ petition civil 13218 of 2013 is restored to the file of the court. Then in the main writ petition, you say on the short ground that the petitioner purchased the property in question under registered sale deed dated 20th January 1992, whereas the impugned order was passed by the resumption order was passed by the Tahsildar Bhubaneswar in lease case number 158 of 1989 on 30th April 1998 without notice to the petitioner, the said impugned order is hereby set aside. The lease case number 158 of 1989 is restored to the file of the Tahsildar Bhubaneswar and will be listed there for directions on 3rd November 2022, on which date the petitioner will appear along with the downloaded copy of this order. Stop. The Tahsildar Bhubaneswar is requested to proceed in accordance with law and dispose of the said lease case within a period of 4 months thereafter, till such time status quo shall be maintained vis-a-vis the property in question.
Orders item number 2.
On last occasion, your lordship, the matter was dismissed for default due to non-prosecution from my side, your lordship. To that effect, I have filed an IA interim application stating therein ground that the consent.
What is the main matter about?
Main matter is relating to OGLS Act matter, your
So when
lordship.
did you purchase the property?
The property was allotted to me in 2081, your lordship. And 1981, your lordship.
What is that to show that?
It was allotted to me as under the WL case, your lordship, wasteland lease case. And the proceeding was initiated in 2000, your lordship. Well, after a lapse of 14 years, your lordship. That is the main ground of my writ petition. There is a bar that
He is not a purchaser. He is a lessee himself. He is taking that ground which your lordship has already decided is Asahans versus State of Orissa. That 14 years following the Brindavan Sharma case, this delay, so far as this fraud is concerned, where fraud is there, your lordship has decided in Asahans versus State of Orissa.
Anyway, we'll simply restore it. You say for the reasons stated therein, the application is allowed. Order dated 4 July 2022 is recalled. And it petition civil 21062 of 2012 is restored to the file of the learned civil judge. Restored to file. The main writ petition is said today by a separate order. This writ petition has been restored. List before the roster bench on 17th October.
obliged, your lordships.
Item number 3.
May I please your lordship, on behalf of Mr. S.K. Samantrat. The petitioner has prayed for modification of order dated 19/7/2022.
Modification, setting aside, madam. So matter dismissed in default.
My lord, our item was.
No, it's okay. We are recalling it. But what about the main matter? It's an OGLS matter.
It's for additional sub-collector, challenging the order of additional sub-collector cum settlement officer, passing an ex parte order dated 14/8/2013. It is an survey settlement act and OGLS.
Or we simply restore it to the file of the court. Same order and list on same date.
Item number 4.
Dear my lords, under section 12
after the judgment of the NCLAT, the moratorium was over, Annex 12 at page 271. That was on 13/12/2018. Unfortunately, I could not bring to the notice of this honorable court. So, my lords, on 29/6, lordship directed me to make the payment from
We'll just issue notice because the other side is not here.
yes, that they are.
So I am appearing. to you.
Well, let's
You agree with what he's saying?
No, I have just been served.
no, I have already saw the copies. Earlier, it is the copy, my lords. I am not saying anything else, my lords. I am not asking for refund, nothing of that sort. Well, as I have.
He has to agree with you that the date has to be something else because of the moratorium date.
Yes.
Extends up to a certain, he has to agree with you on that. Only then we can say that whatever you put in excess should be adjusted.
Adjusted.
If he is unable to agree to, you can't pass that order.
No.
Well, are you in a position to agree? with what he's saying?
No, I'll seek time.
All right. IA number 11889 of 2022. Say notice, he accepts notice and seeks time for instructions. List on.
So the matter is coming on 28th of September.
Yeah, that's before the regular bench. So we'll keep this on 23rd.
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 All right. AK Mahapatra. Let's.
Supplementary list item number 1.
Yeah, the office note has been produced, the correction be carried out as indicated.
Item number 2.
Same, the correction be carried out as indicated.
For admission, item number 3.
Alert.
I am for the opposite. I am for the opposite.
Kindly speak in the mic, sir.
As
I am for the opposite party.
You're not for the review petitioner.
No, I am the review petitioner.
Say
Your lordship, kindly see the last order. Your lordship has directed to serve copy of the writ petition connected matter. The petition, the opposite party who is the writ petitioner, he derives right from a particular order which has been challenged before another court and stay order has been granted. So I prayed before your lordship that the review petition, adjudication of this review petition may kindly be kept in abeyance till that this petition is disposed of by Honorable Justice B. Mahanti and Honorable Justice S. Ratho. And your lordship
It's still pending.
It is still pending.
It is stated that reproduction civil.
My lord, already writ petition already disposed of.
When?
14/12/21.
No, it's a 22 writ petition, sir. Writ petition civil 14454 of 2022.
I have already filed counter in that case.
That's right, it's still pending. That writ petition is still pending.
Yes.
Where is it listed?
So one writ.
Sir, writ petition 14454 of 2022. When is it listed?
My lord, there is what I know that no date is fixed, but he has filed the counter. Let them, your lordship may direct that this review petition will be heard after disposal of the order.
The present review petition is adjourned sine die, awaiting the disposal of writ petition civil 14454 of 2022. Full stop. List the present review petition. No, it will be open to the parties, either of the parties, to mention the review petition for listing after disposal of the aforementioned writ petition. All right.
My lord, one's writ judgment stopped by another writ petition.
Anyway, all right.